board really has the authority to do so. The second point would be that there are established processes for addressing this question if there's a concern about this. And so those processes would be different than the proposal to call for an election. So the state law would suggest that an initiative process that comes forward from the population would be a more appropriate channel for addressing this kind of question. And then finally, around the legality of it, the board does have the authority to call for an advisory election, but then that would provide no effect as far as changing the election for the superintendent or any future superintendent. And it would provide information to you about potentially election or voter interest, but really not put the board in any position to change. So that sort of summarizes briefly the legal analysis around the question and the viability of moving forward, to successfully accomplish the goal of changing the superintendent selection process. There are a couple other points that have come up over the years as we have evaluated this. And one of the legal points is that in the history, and I believe it was back in 1978 or in that time frame, this question was put to the voters in Contra, Costa County, and the voters did make a determination that they selected for an elected superintendent. So there's sort of that history about the question of overturning or seeking to overturn the will of the people at that time. Is another point that the attorneys raised in their evaluation. And then turning to the points 5 and 6 on the analysis, there is documentation, history about similar efforts to seek to persuade voters to change their position with respect to elected superintendent, and those have consistently failed. There really hasn't been success in having the election, the electorate overturn or reverse their decision once they've made that decision about a county superintendent. And so that's basically a historical track record that you have about the success of these kinds of proposals. And then finally, on the cost area, we did communicate with the elections office, and they estimated the cost to be $655,000 to host this item. That would lock the county office into that cost regardless of what happened with any other election. So if the superintendent was an uncontested or the board members were uncontested, and that does happen, that's a frequent occurrence here. Should the board move forward with this, we would be locked into $655,000 cost, as far as the election and having this on the ballot, regardless of any other elections that might move forward. So on the cost area, we do have concerns because of the fiscal challenges that the agency is facing, that we would be committed to that kind of an expense, along with the other costs around establishing the legal authority to do so, the research that would require, and so on. There would be other expenses associated with the effort. So I think that sort of summarizes, briefly, both the legal and historical and also cost impacts with respect to the proposal.
Okay, I would wait. I do not want to be characterized as a member of the board that is waiting for this, or do I want to be characterized as a member of a board that wants to take the next step?
Okay, that's fine. You're out of this then, huh?
Well, I do not support this.
Okay, let me go over this, try to answer some of those questions that you posed by bringing up what you did. Well, first of all, the cost involved. There's over $200,000 set aside in the current 2013-2014 budget. Now, using the same proportions as your quote there from the County Office of the Elections Division, those three replacement ballot measures would cost $1.32 as opposed to $1.25 for the three replacements. So, you already have enough money to cover the, what is it, $665,000?
$665.
Where did you get that figure from?
I can tell you that, the election office was reluctant to give us a number. However, they did give a, I'm sorry? Yeah. However, they did provide us information. They said based on the registered voters at $1.25. And so, and then we reviewed that calculation. They said, yep, you are correct. This is the cost that you should anticipate in the event that you move forward with this. So,
Well, I know, I have doubts about that, okay? I think it's a wild guess, and we really won't know about it. Now, about all these legal questions, you know, that are brought up from legal opinions brought up in the past on the same subject, and that you imply that if it goes the other way for you, you're gonna spend still more money on trying to find out whether or not this board has the authority to go forward with this resolution. Okay, I can solve that for you, and it's available in the resolution itself. You won't have to spend another dime on this. The county council will provide an impartial analysis about existing law applied to the resolution, and they'll also give you an idea of what the legal impact of the resolution is going forward for the extended life of the resolution itself. Now, as to the failures of this in the past. Hey, we have candidates that keep coming back to be attempted to be re-elected to office. That doesn't say that they can't do it. It says they're able to do it and then they do it. We have a constitutional Article 9, Section 3 of the Constitution says that this is available. This process is available each and every year. It doesn't say based upon whether or not it's been successful in the past or not. It's available. It's for people to change their mind. And people are changing their mind all the time. Now, usually it involves a scandal, but there may be good reasons. There are a lot of good reasons, I'll tell you about. In fact, over 1,000 reasons. And that's because every single school district in California has a CEO or superintendent that's appointed by the board. Those boards have ultimate authority over that superintendent. And that's what I'd like to see for all county offices of education. We should follow those examples and the examples of corporate democracy. There isn't a publicly traded company in the United States, and maybe worldwide, that doesn't have a board of directors equal to the council here that appoints a CEO. Now, some of them may get around it by being appointed also as chairman of the board. But that doesn't mean anything. That means the chairman has one vote when he's sitting as chairman. But a CEO, they're directly under the control of the board itself. So or at least I'm speaking only for myself, and I've always spoken for myself in regard to this, and no other member of the board. The board is free to make up its own mind when we get to a resolution of this. And that's what I want to find out. When can we resolve this? You seem to, I'll tell you, it seems to me that the superintendent and some of his staff may be stalling and hoping to get by March the 11th. March the 11th is the deadline on putting this, on moving this forward to the county supervisors and the elections division and the county council. They need 240 days preparation time to check it out legally, to check it out fiscally. Well, I don't see, what are we going to do here? We have 2 meetings coming up. Let's see the exact dates, but we have 2 meetings coming up.
February 19th is the next one.
Yeah, okay. Now, if you keep delaying this, you're going to force us into doing a special board meeting where nothing else will be considered except this resolution.